If they're young, they're dumb. They shouldn't be. If they're an eagle, they shouldn't be hanging with the chickens because the chickens will bring you down. I would say that.
I hear that, but I also I understand. I'm sitting up there looking at this young man, and I realize he doesn't have a record. I realize all of those things. I also realize there's some very dangerous and tragic things that have occurred, and he has in his possession. And if he has them in his possession and participates in the cover-up of that, it really becomes an assessment of how dangerous then is this individual. Because you can be stupid and dumb and still dangerous.
But you can be young and dumb and make a mistake and go to jail, and then you're like, I don't like this. I'm not going to do it anymore.
Dangerous. Where would he stay if I were to release him? Go ahead, put their appearance on the record. Or you may go ahead.
Yes. Okay. Good afternoon, Your Honor. Robin McCoy on behalf of Mr. Makai Nunn, who stands to my right, P63057.
All right. This is your motion regarding bond.
Yes. Okay. Yes. So just so the court is aware, I know when I was last year, I did not have the discovery. I did receive the discovery, the paper discovery. I reviewed all of the paper discovery. I would note that there is reference to a video, which my understanding from Madam Prosecutors that they're working on getting video. As I said in my motion, Mr. Nunn, and I've known him actually all of his life. His mother worked in our office for about 10 years. His father is here. He has two sisters here, a girlfriend, and I think it's a cousin that's here. He is gainfully employed, and he has an apartment. He has no prior record, no juvenile record, nothing of the sort. As I reviewed the discovery, and I did see there are some discrepancies, and there's some things that we obviously need to look at. We are asking that.
You mean discrepancies?
Well, discrepancies. I did see what the prosecution wrote in their response. The fact that when I was reviewing the report, it said that he was not under arrest and he was questioned, and he says he was never Mirandized. And then I did see that the officer said that he, based on what he alleged is Mr. Nunn's behavior and the evidence from the video, which we don't have here today, which they referenced some things happening on a video, that they went and got a search warrant. And so then that would lead me to believe, again, I don't have the video, that there might be some issues with the search warrant, and that all that was found was the fruit of the poisonous tree. If it's invalid questioning, he's not Mirandized.
Okay, but what bearing does that have on his bond?
Well, I would say this. They reference certain things in the police report as a means to refute the bond. And I was not at the arraignment. I understand that the bond was set at $100,000. As I said, he has no prior record. In this situation, we're asking for a PR bond. If the court, because of the nature of these allegations, if you want to have a tether, we would say we'd have a tether, let him go to work, go to grocery store, go to doctor's appointments. I did talk to Reverend Green, and he said that he would work with him and talk with some of the other. I talked to Pastor Harold Wimberly, who works with the youth, who also said that he would work with him. But as I review the police report, I would say this too. This is not a situation. I'm not going to name the names that are in there, but they basically are talking about other people that are involved with certain activity and pictures of other people that are not him involved with activity it's not him being involved with that activity. This is a friend. One of them is a friend that he grew up with.
Okay. But I still got an answer to my question. You're saying there are internal discrepancies with?
Well, in the discovery, it says that he was questioned about, I'm talking to him, it first says that he ran when the police came. He says that when the police came, he said he had worked a full day at his job, and we can get documentation to substantiate that. and that he came out to his car to get his charger, and then he was questioned by the police about where he lived, and that he says he told the police where he lived, and that he was not dishonest about where he lived. And they're also alleging that he said something about not going to the hospital. He did say that he went to the hospital to visit one of his friends from school who had been involved with the shooting, and that there was. So then the police were questioning him, and they were asking about searching his apartment, and then there was obviously some things that were found in his apartment. He said that he believes that somebody was let into his apartment and did certain things that he was not aware of, and that there's allegations that the items that were found in the apartment were involved with other offenses, which again, he has nothing to do with, has no knowledge of any of that.
I don't know for purposes of bond if it's something we need to get into, but who has access to his apartment?
So there in the police report, it says that he's the only one.
No, who are you saying has access to his apartment?
On the lease at the time, it's him and his girlfriend that are residing in the apartment. So it's the way the report is written is he's the only one that lives there. But at the time, it was himself and his girlfriend that lived at that. Not the current girlfriend, but a girlfriend.
I mean, am I to take then from your argument that as to what was located in the apartment, and certainly during this process you can challenge it, but he's saying that wasn't his?
Correct.
And that it belonged to somebody else who would have access to the apartment, which would mean it belonged to the girlfriend.
Not the girlfriend, but he believes that the girlfriend allowed somebody else to access the apartment, and that the other person who was involved with, what's referenced in the report is that there was some kind of shooting, and his friend Sarah calls him up and says, "Hey, I was involved in a shooting and she was at the hospital." He said he went to visit her at the hospital. She was pregnant at the time. He says that she had baby clothes in her car and she wanted him to take the baby clothes. He took the baby clothes and then he went to his apartment. And then he said she was still upset and that she comes over there to meet him at the apartment and he's trying to calm her down and she's upset about the situation. But he believes that his girlfriend let her boyfriend in, and that it's the boyfriend's items that were found in the apartment, not his.
And it was who?
The boyfriend, Sierra's boyfriend.
All right. Anything else?
Again, I would just say I've known him all his life. I've never known anything like this. He did graduate from Ypsilanti High School. He's had a pretty solid work history. He worked before. I know he worked at the noodles company. I would often see him there. He does not have a criminal background. And his family is here. His father is here. His mother, she's working right now. Everybody is very obviously distraught. He's never had anything like this. He's upset about this because he's like, this is not me. He has assured me that this is an experience. He will not associate with the people he associated with before. He said this is one and done. I know the court and, neither of us are necessarily spring chickens. We hear stuff all the time, but
I'm a spring chicken.
I
don't know about you, Mr. Boy. You can comment on your own age, not my.
I would just ask for him, and he said he's willing to take a lie detector test as well. So I'll just put that out there.
All right, response from the people.
Your Honor, the people are concerned because this matter does tangentially involve a shooting. The defendant lied several times to the police officers during their interviews. Even the story today that's been represented by counsel is an additional new story. He first said that he went by the hospital, did not stop his car, did not get out, did not find who he was looking for and left. Then when he was pushed back by the officer who mentioned surveillance footage. He said he stopped for a minute, looked around, still didn't see her, and then left. Now today he's telling a story where he did stop, he did find the vehicle, he did find who he was looking for. He was moving stuff back and forth between the vehicle that was involved in the shooting. Yeah, this is just a deeply serious matter where I have no faith that we're being told the truth.
And Your Honor, if I may respond again, I wasn't there. The prosecutor wasn't there. This police report was written up. This is my second time talking with my client about the situation. There has been, from my standpoint, consistency where he was saying that his friend called him in distress and he was trying to help comfort his friend who was pregnant at the time and has now had a baby. And there has been consistency there. He said that at the time he was questioned, he had worked a full day, he was tired. He said that he had no intentions of being dishonest with the police. He had no idea what was in his apartment. And he said that he has had some bad experience in the past with the police. So he did obviously, I think a lot of folks have PTSD, anxiety when it comes to the police. So, but what we have is we often get reports. A lot of times I get what's in the report, and then I talk to my client. The client will say, even when they give written statements and they sign off on it, they say, that's not what I said. That's why I typically tell clients, don't say anything. Don't say anything. Tell me the truth, but don't say anything to the police talk to me, tell your mama the truth, and then just zip it when you're dealing with the police and don't lie.
You would acknowledge that were he tied to what was found in the apartment, that makes him a danger to the community.
I would acknowledge that, yes.
And so I've got to then go on some limb to find that he's not a danger to the community because it's found in his apartment.
Well, if Your Honor.
And if I can just finish, please.
Okay.
I don't have anything else that points to those items belonging to someone else.
Well, in the report, though, it does say that the items belong to Devon, to someone else. It doesn't say that the items belong to him.
I know.
It just says the items are found in his apartment.
But they're involved in a crime or crimes, and they are now in the defendant's possession.
In the defendant and his girlfriend's apartment. Correct.
But how does that help me, Ms. McCoy?
If
I have two people in an apartment, then are you saying that it's the girlfriend? I mean,
what we're not saying it's the girlfriend. We're saying what we believe is that the girlfriend let this other person in there, and the other person put his stuff there, put from the shooting.
Do I have anything that says that? I mean, other than the statement today, is there anything or any statement given that scenario occurred?
I would say that we would need to talk to the girlfriend to see what her statement would be, and also talk to Sierra about what happened at the hospital. So, but I would say, again, Your Honor, I understand you. That's why we're saying if you put him on a tether, then we will know where he is. He's got to go to work.
It isn't the question of necessarily knowing where he is, although that becomes an issue. It becomes an issue of an assessment of this individual's threat to the community. That's what it becomes. And if the scenario that you have forth can give then one assessment to those items being in that apartment. But if the defendant is tied and or hiding those items in that apartment. That's a very different scenario,
Correct.
a very different analysis for the court as to what the court should do. But I don't, the part that would favor you would be if there's some indication that someone else let them in, that being his girlfriend, and that there's this other party that put these items in to his, and I say his possession because it's his apartment too, but puts it into his possession, then that becomes something very different. But I don't have that. I hear what you're saying, but I don't have that.
Right.
And you acknowledge that if those items are tied to him, that he would be a danger to the public.
I would not say if, again, I wasn't there. I would say if
McCoy, you could try to sidestep it all you want.
no, Your Honor, I just want to make sure I'm clarifying for the record. If he was involved, if he's lying and if he was involved, what the complaint, the 123 pages of the discovery clearly, repeatedly say is that there are other individuals out there that are a danger to society. And the allegation against him is that he lied about what happened, lied about his apartment, lied about what happened at the hospital, and that there were items found in his apartment connected to what the other individuals did. And there's pictures and it's littered with indications about these other individuals. So what I would just say is that the presumption is that you're innocent till proven guilty. Although a lot of times in our society, you're treated as if you're
not going to try to give me that lecture.
Guilty till innocent.
I've been doing this way too long.
Right.
Don't try to give me that lecture.
Okay.
I just need to try to talk. I want to talk about his particular interactions.
Okay.
If all of these things had occurred as they were, and an individual, how should I say it, participates in a cover-up of those crimes,
Right.
would you consider that person then to be a danger?
I would consider it definitely would be a problem. If they're young, they're dumb. They shouldn't be, if they're an eagle, they shouldn't be hanging with the chickens because the chickens will bring you down. I would say that. He's 21, no prior record.
I hear that, but I also I understand. I'm sitting up there looking at this young man, and I realize he doesn't have a record. I realize all of those things. I also realize there's some very dangerous and tragic things that have occurred, and he has in his possession, whether jointly or by himself, the instrumentalities of those that help commit those acts.
I understand. Yes.
That's the problem.
Right.
And if he has them in his possession and participates in the cover-up of that, it really becomes an assessment of how dangerous then is this individual. Because you can be stupid and dumb and still dangerous.
But you can be young and dumb and make a mistake and go to jail, and then you're like, I don't like this. I'm not going to do it anymore.
Dangerous.
Well, I would say he's 21. The adult brain doesn't fully mature till the age of 26. Some people would say 30s for some folks. He has a job. He has an apartment. He said to me, all he does is go to work. He did get caught up with the situation. Even
Mr. McCoy, where would he stay if I were to release him?
if you were to release him, he could go back to his apartment, or if the court is saying, no, you're not going back there. He could stay with his parents, and they live in Ypsilanti, which I can give the court the address. I just don't want to put it on the record because of, yeah, I would rather just give the prosecutor and the court that privately. He has a sister that's in college in Detroit. He has another sister that lives in Columbus, Ohio.
So where would he, in your,
His mom, I talked to his mom. She said that he could stay with her and his father at their residence.
we're off to a good start.
Your Honor, can I provide the court with that plea form?
Apparently, you didn't hear what I just said, but that's okay. She's at. I don't have an advice or right side.
Your Honor, I do have one in my possession. I just asked Ms. Welsh if I have permission to sign on her behalf as we discussed, Ms. Welsh.
Yes.
Your Honor, I'm happy to come back in a week on this and make sure that the documents are all in order.
That would be good.
Okay.
That makes my life easy. Everybody's life easier.
Your Honor, I'd ask.
Well, I have to go 2 weeks out. Is she gonna still be in Livingston County?
Her release date is July 15th, Your Honor.
July 15th? Then I'll tell you what, if she's getting released on the 15th, I'll just set this for the 16th.
Okay.
Well, if she gets out on the 15th, I'll set it for the 16th. If she's out, she can appear however she's going to appear.
Okay. Thank you, Your Honor.
Here, thank you. You're
Thank
gonna
you.
need. So I'll adjourn this to July 16th, 2026 at 9 a.m. Bond will continue.
Thank you.
Yeah, thank you, ma'am.
Thank you, Your Honor.
Court calls the case, People versus Tyler Cochran. Good morning.
Good morning, Your Honor. William Amadeo, P 76194, with Mr. Cochran, who should be coming in from the Washington Jail. Tyler, please state your name for the court.
Tyler Cochran.
At this time, defense is going to waive their prelim if there's no objection from the defense. I'm working on a global resolution. I should say resolution circuit court.
So you're waiving your right to a preliminary examination?
Yes, Your Honor.
You understand that that's a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yes, Your Honor.
You understand you'll not have that hearing. You'll proceed to circuit court for further resolution.
Yes, Your Honor.
People also waive their right. Preliminary examination having been waived. Defendant is bound over to circuit court on counts 1 through 5 with 6 following. Mr. Amadeo.
Your Honor, will waive a formal reading, stand mute, and ask for a pretrial date.
Defendant having waived formal reading, standing mute as to all charges. Court will enter not guilty plea. Pretrial will be set for
July 28th at 1:30 with Judge Funky.
July 28, 2026, 1:30.
Thank you, Judge.
Bond continued.
Oh, remember, we have to send information.
Yes. I don't know where Alan is. Where? Oh, there he is. He's arrived. No, it's okay. Court does call the case. People versus Cameron Hall.
Current bill from people, Your Honor. In Zilch.
Sherilyn Foster Tucker on behalf of Cameron Hall. Mr. Hall, can you state your name?
Cameron Hall.
Got it. All right, I got it.
And Your Honor, we're requesting a preliminary exam in this matter, and if I may address bond briefly.
Discovery is complete.
To my knowledge,
What? Go. Alicia. Got it. What date are we on? People, this is available the 21st. Preliminary examination in person, July 21st, 2026, 9 a.m. before Judge Barr. As the bond.
Your Honor, I believe Mr. Hall's current bond in this case is 5,000 cash surety. He does have a case pending in front of Judge Barr, which should be resolved today. I believe he will be asking for a reinstatement of his bond in that case. His bond is currently denied in that case, is my understanding. He's just asking if the court would consider
What kind of charge is he before Judge Barr on?
stalking, Your Honor.
It's a stalking charge.
In front of Judge Barr, yes.
And my understanding is he's set for trial today.
Yes.
Right.
Yes.
Okay. All right. Response.
It's, the Barr case is a domestic stalking daughter.
Oh,
He's
probably should have led with that, but go ahead.
asking for the court to consider either a 10% or nominal bond in case that case is resolved and he has a bond today.
At this point, I'm going to deny your motion. Changes bond will continue. Thank you.
Thank you, Your Honor. Mr. Hall, I'll come see you.
Okay. Court calls the case, People versus Tegan Donnell. Donnell.
Morning, Your Honor. Raymond Cook for the people.
Assistant Public Defender Zach Vinue, with and on behalf of Ms. Donnell, who's present via Zoom. Ms. Donnell, can you please state your name for the record?
Tegan Donnell.
Your Honor, we're filing for competency in this matter. We would request an adjournment for that purpose.
Pardon?
We're filing for competency in this matter. You should have the form. We would request an adjournment for that purpose.
Forensic evaluation will be ordered. Competency hearing in this matter will be set for
October 8th.
October 8th, 2026, 9 a.m.
If I may
Bond
speak, I apologize for interrupting.
I'm sorry.
If I said I'm not meaning to interrupt you, but if I may speak on a matter.
Ms. Donnell, you do have a right to speak. I would advise you not to, but that is your right.
But when he's done, I need to speak because we discussed the legal matter and you're ignoring me completely. So I guess I have to represent myself.
You want to represent yourself?
I guess so, because he's literally declining to step forward on something that's completely blatant in the case that makes it non-valid. The 14-day rule is a literal law that you cannot, if you're not arraigned or done such and such in the matter on any case within 14 days, you cannot arraign the case at all whatsoever. It has been almost 90 days and you've not done anything in this case whatsoever. And he tried to make me think
90 days.
for some reason.
It's been 90 days since when, man?
No arraignment.
Your Honor, may we approach?
Pardon?
Your Honor, may we approach? I may be able to explain.
May. All right, record should reflect we've had a bench conference in this case. Mr. Bell, what I'm going to indicate is I'm going to leave this set for a competency evaluation. If you believe that a right of yours somehow been impinged, I'd suggest that you get to your attorney. And if they wish to file a motion or believes that it's appropriate legally or otherwise to file a motion, then they can file a motion before the court and I'll hear it. All right, thank you.
I don't have a lawyer but this case is almost over. This actual case is almost over. That being said, you have not done anything within 90 days. You can't just randomly do or take legal action, 70 days later.
Ma'am, I
Yes, sir.
realize you're trying to tell me with your law degree what I should do. I just told you what I will do. That is how we're going to handle it. You do have an attorney representing this case. All right, thank you.
I said, could you repeat what you're doing? So release to treatment?
No. Somebody's going to come down and they're going to talk to you and evaluate you, okay? And then we
Okay,
can decide where to go from there.
All right.
Okay, thank you.
Thank you, Your Honor.
I would say the same, but not. Court calls the case, People versus Xavier Bonner.
Morning, Your Honor. Raymond Cook for the people.
Should be Mr. Amadeus. Oh, it's Mr. Amadeus.
Where is he? He was all up in here.
Morning, Honor. William Amadeus, 76194. We have a Xavier Bonner. Xavier, please state.
Honor.
Judge, I just got an accurate phone number from Mr. Bonner. I took over the case about a week ago. I'd asked for a 2-week adjournment to communicate with him. I do believe there might be discovery coming from Prosecutor Cook.
Without objection, July 23rd, 2026, 9 a.m. Bond continues.
Thank you, Judge.
Court calls case of the People versus Sky Freeman Jones.
Morning, Your Honor. Raymond Cook for the people.
Good morning, Your Honor. J. Grant Miller, P58658. We're going to request a chambers conference, Your Honor.
Chambers conference?
Yes, Your Honor.
Want me to stop in the middle of everything right now?
I apologize. I hadn't spoken to Ann this morning, but I had indicated it to the other clerk. I didn't expect to be called. I apologize, Your Honor.
I'm not gonna have everybody wait while I do that. We'll take her back if you think that's necessary. I don't.
Your Honor, we're just
right now.
Your Honor, we're going to ask for a referral for competency.
Do I have an order?
I have not prepared one, Your Honor. I've been working all morning.
Forensic evaluation is ordered. Competency hearing will be set October 8th, 2026, 9 a.m. Bond continued. Thank you. Court calls the case People versus Eric Buckner.
People, Your Honor.
Okay.
Why does he keep leaving? Just chaining the Goldstein.
Morning, Your Honor. William Amadeus, 76194 for Mr. Buckner. Eric, please state your name. Your Honor, we'll be waiving the prelim on this, working on a global resolution in the circuit court.
So you're waiving your right to a preliminary examination?
Yes.
You understand that that's a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them. You understand you'll not have that hearing. You'll proceed to circuit court for further resolution. People also waive their right. Preliminary examination having been waived, defendant is bound over to circuit court on counts 1 through 3 before following.
We'll waive a formal reading stamp muteness for a pretrial date.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea to all charges. Pretrial in this matter will be set for
September 130 or Judge Hunky.
September 1st, 2026, 1:30.
Thank you, Judge.
Thank you.
I'll be in touch.
May I approach the sign of it?
No. No. Court calls the case People versus Jesse Hardman.
Bring it over for the future.
Morning, Your Honor. Edward Drupes on behalf of Jesse Hardman. This is a waiver, Your Honor.
Jesse Andrew Hardman?
You're waiving your right to a preliminary examination.
Yes, Your Honor.
You understand that that's a proceeding where the people would have to show by probable cause that the offense alleged was committed, the offenses alleged that were committed and that you committed them.
Yes, sir.
You understand you'll not have that hearing. You'll proceed to circuit court for further resolution.
Sir.
People also waive their right. Preliminary examination having been waived, defendants bound over to circuit court on counts 1 through 7 with 8 following.
Your Honor, roll acknowledge receipt of the waive reading.
Defendant having waived formal reading, standing mute to all charges. Court will enter not guilty plea. Pretrial will be set for
July 20th at 1:30 with judgment.
July 20th, 2026, 1:30 before Judge Hammoud.
Thank you, Your Honor.
Bond continued. Thank you.
Yes, same as.
She's getting on my nerves. Court calls the case People versus Terrence Hall.
Good morning, Your Honor. William Amadeo, P76194, on behalf of Mr. Hall. Terrence, please state your name for the court.
Terrence Hall.
Your Honor, this time asking for a 2-week adjournment. I was put on this case about a week ago. I want to make sure I have all discovery and we'll decide which way we're going to go if that's acceptable to the court.
No objection. July 23rd, 2026, 9 a.m. Bond continued.
Thank you.
Court calls the case of the People versus Justin Heaton.
Ready to go. There.
Robert, on behalf of Mr. Heaton. Justin, please state your name for the record. Justin Heaton.
Thank you.
Your Honor, may we approach?
Yes. Record should reflect we've had a bench conference case. Requesting an adjournment of this matter. I'll grant that adjournment. Without objection. I'll adjourn probable cause to July 28th. 2026, 9 a.m. That's a Tuesday.
Okay, understood. Thank you, Judge.
Bond continued.
Thank you.
Thank you. Court calls the case of the People versus Christina Eicher.
Morning, Honor. Good
Good morning, Your Honor. Marcia Creature on behalf of Ms. Eichert.
Ms. Eicher, can you state your name, please?
Christina Eigard.
Thank you. He's waiving.
Yes, Your Honor.
Ma'am, you're waiving your right to a preliminary examination? Is that
Yes,
correct?
Your Honor. Yes, Your
You
Honor.
understand that that's a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it.
Yes, Your Honor.
You understand you will not have that hearing. and that you'll proceed to circuit court for further resolution.
Yes, Your Honor.
People also waive their right.
Yes, Your Honor.
Preliminary examination having been waived, defendant is bound over to circuit court on the single count. Ms. Krejci.
As to the arraignment, Your Honor, we ask the court to waive the formal reading of the information. And we stand mute, Your Honor.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. Pretrial will be set for
Judge Conlon.
August 5th, 2026, 1:30 before Judge Conlon. Bond
Thank
continue.
you. Thank you, Your Honor.
She's like, once. I don't want that. We need to get into a fight. And I'm sorry. Court test, call the case, People versus Lewis McSwain.
Ashley Feltus for the vehicle.
Good morning, Your Honor. William Amadeo, P7-194 with Mr. McSwain. He was here. He was right. I apologize, unless you passed, he was here, he probably went to the bathroom.
What if I said no? You're walking away.
You're the boss, I'll say.
I know. Didn't act like it.
And I apologize.
Sure. Showed up. I knew he was here. He was telling me to bench warrant you.
That's not true.
What? And I said, no, I'm not doing it. I was looking out for you. All right, what are we doing?
We're proceeding to preliminary examination, sir.
Discovery is complete.
Yes.
And would the people have their witnesses available the 21st?
Yes, sir. We'll try for that date. Thank you.
All right. Preliminary examination in person will be set for July 21st, 2026, 9 a.m. before Judge Moore.
Thank you.
Bond will continue. Thank you. Court calls the case of the People versus Josiah Miller.
Ashley Feltus for the vehicle.
Appearing on behalf of the defendant. Your Honor, I heard what the court said earlier. I do think there's a conflict in this court. Ms. Feltus thinks my client is guilty and I don't.
There's always a conflict then.
State your name, Josiah.
Miller.
Your Honor, we're going to be waiving exam. My client has to sign the waiver form.
All right. So you're waiving your right to a preliminary examination?
Sir.
You understand that that's a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it.
Yes, sir.
You understand that you'll not have that hearing and you'll proceed to circuit court for further resolution.
Yes, sir.
People also waive their right.
Yes, Your Honor.
Preliminary examination having been waived, defendants bound over to circuit court on the single.
My client waives the reading of the information in this matter, Your Honor. My client stands mute, asking a not guilty plea be entered.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. Pretrial will be set for
July 28th at 1:30 with Judge Conlon.
July 28th, 2026, 1:30.
All right, thank you, Your Honor.
Thank you. Bond continued. She's stalking. Court calls the case, People versus Lance Ford.
To the people, Your Honor.
Trophy on behalf of Mr. Ford. He's in the hallway.
That doesn't do me much good.
That doesn't. I'll go grab her.
About the time.
Your Honor, Mr. Ford, state your name.
Lance Ford.
Your Honor,
Yes.
I've spoken to Mr. Ford. We're asking to not actually follow the green sheet. Mr. Ford. Mr. Ford again this morning. I spoke to him yesterday. We spoke again this morning. He wants to set this for an exam.
It's not a weapon. Is all discovery complete?
And that, Your Honor, I've explained to my client that I don't have a full discovery. My client is adamant that we set this matter for an exam. I explained to him the normal course is for me to ask for a permit back in discovery, which I would have good cause to do. But Mr. Ford wants to set this matter for an exam.
Is that right, Mr. Ford? Even though your counsel is saying he doesn't have everything that he needs?
Yeah, I was trying to move forward process.
People have their witnesses available the 28th. Preliminary examination in person will be set for July 28th and 26th noon. That's before me.
That's what he just said, preliminary exam.
If you guys aren't ready to go, I'm not gonna entertain an adjournment or anything along those lines because you don't have discovery.
I 100% agree.
You'll just sleep in the bed that you want to lie in. Thank you. Bond continued.
Thank you, Your Honor.
Court calls the case, People versus David Sarpo.
And Lisa, on behalf of the people, Your Honor.
Good morning, Your Honor. William Amadeo, P76194 for Mr. Starpo, who will be coming up standing to my right. David, when you approach, please state your name for the court.
David Sarpo. Thank you.
Morning, Your Honor. My client and I met last night. He wants to proceed to a preliminary examination.
Discovery is complete.
Yes, sir.
People have their witnesses available the 21st.
Starbucks, Your Honor.
Preliminary examination in person will be set July 21st, 2026, 9 a.m. before
Judge Barr.
Judge Barr. Bond will continue.
Thank you.
Court calls the case, People versus Deshaun Jones.
Go for the people. Morning, Your Honor. Edward Drugas on behalf of Deshaun Jones.
Deshaun Jones. Thank you.
There's a green sheet in the file. We'll be asking for an adjournment. We're close to setting up that meeting that we've been working on.
You're trying, okay, but so how much time do you need?
Shooting, it's been sort of a hiccup because the original OIC retired and you're trying to figure out how to schedule the new OIC and all that. I think 2 weeks will give us something to figure out our plan. We'll be able to actually schedule the poly given all the shuffling of the agency.
Got it. Probable cause conference, July 23rd, 2026. 9 a.m. Bond continue.
Thank you, Your Honor.
Thank you. Court does call the case, People versus Devon Thompson.
Your Honor, we go to the people.
Counsel Zimzo.
Your Honor, good afternoon. Marcia Crater on behalf of Mr. Thompson.
Your name?
Devon Thompson.
Thank you. What are we doing?
Your Honor, we'd be requesting pursuing a preliminary exam.
All discovery is complete.
Yes, Your Honor.
People have their witnesses available the 21st.
Do our best, Your Honor.
Preliminary examination in person will be set July 21st, 2026, 9 a.m. before Judge Moore. Bond will continue. Thank you.
Thank you, Your Honor.
Court calls the case of the People versus Scott Kidney.
Good morning, Judge Carpenter, on behalf of, but not with Mr. Kidney. May we approach?
Were you gonna do this all day?
Yeah, I only got one more. Yeah.
You just start walking out. Alan will take you down in a minute. Come on.
Just about one of the few guys about my height.
Can you get your polycom, Your Honor?
Record should reflect you had a bench conference in this case Probable cause conference will be adjourned to July 28th, 2026, 9 a.m.
Thank you, Judge.
Thank you. Bond continued. What are you two? Court calls the case, People versus Aaron Burrows.
Brother Judge, Marshall, first assistant public defender on behalf of Mr. Evan Burrows, who is approaching the podium. Mr. Burrows, when you arrive, please state your name for the record.
Aaron Burrows.
Thank you, Judge. According to the note file, this matter was supposed to be have a plea resolution, but we have not been able to get that completed and into court before today's date. We'd be asking for a brief adjournment to get the plea resolution into the court.
So you've already resolved it. You just have to get the paperwork in.
That's what the notes indicated, but I haven't talked to Ms. Dover about it.
I wasn't able to find anything in my file to reflect that. I'm not saying it's true. I'm not sure.
Cannon put those notes in, didn't
Can I plead the fifth?
I just, well, why don't I do it this way? What's only being held on this case, or?
I believe so, Judge.
Then what I'll do, try not to delay the matter. I'll adjourn it out to the 16th.
Thank you.
Have a deal, and then you can figure out what to do.
Thank you, Judge.
July 16th, 2026, 9 a.m. Bond continued. Court calls case of the People versus Daniel Polgar.
Jacob,
We're done.
Covered all on behalf of Ms. Polgar. No means no questions.
Well,
No, not on this one.
thank you.
Please take your name for the record. Daniel Polgar. Just an adjournment, please. From the podium.
From the podium. Your other matter I set for the 28th, you want me to put it then?
Yes, please.
That work for you. Probable cause conference will be adjourned July 28th, 2026, 9 a.m. Bond continued.
Thank you.
And thank you, Judge.
Thank you.
Let me jump over.
Court calls case, People versus Sean Charnley.
Thank you, Your Honor. Alex Warren Green on behalf of Mr. Charnley.
That's gonna go better than the last one you had.
I'll do my best, Judge.
Your name, sir?
Owen Charnley.
Thank you.
Your Honor, I'm going to ask to set each matter for preliminary at this time.
Discovery is complete.
I believe so, Your Honor.
People have their witnesses available the 21st. Preliminary examination will be set July 21st, 2026, 9 a.m. before Judge Barr. Bond continued.
Thank you, Your Honor.
Court calls case, People versus Angela Ball.
Brian Bowling on behalf of Ms. Ball, Your Honor.
State your name for the record, please, Ms. Ball.
Angela Baum.
Your Honor, we're asking for an adjournment in this matter. We're waiting some outstanding discovery.
Probable cause conference. And will all that be clarified by the 23rd? All right. July 23rd, 2026, 9 a.m. Found continued.
Thank you, Your Honor.
Thank you.
Step back behind the bar and I'll be right there.
Court calls the cases of the People versus Grant DeCia.
Morning, Your Honor.
Or DK, excuse me.
Good morning, Your Honor. Ashley Hannibal for Mr. Deshay.
Morning.
Requesting permission to practice pursuant to Michigan Court Rule 8.120 under the supervision of, I don't see Stephanie Cannon here.
That's probably good.
Or Show Feaster.
All right. Permission to practice is granted.
All right, thank you. We are requesting an adjournment in this case. And I don't have a green sheet for all of those when she went out into the hall. I get
You threw her under the bus, didn't you?
Yeah.
I need two.
All right.
Know how much time you need?
2 weeks.
All right.
Can I get the phone?
Any objection from the people?
Oh, you're on.
Probable cause conference will be adjourned to July 23rd, 2026, 9 a.m. Bond continued. Thank you.
Can
Oh.
can we recall this case later to make a bond argument?
Negatory ghostwriter, but why do you want me to call it later?
I haven't discussed with the client, like what we would be arguing there yet. Oh.
Sorry, I'm done.
All right.
Sorry.
Okay.
Do that with somebody in custody because of taking them back and at some point taking back up.
Mr. Desaya, I'm so sorry, Your Honor. Things went bad. I had to step away for a second.
Well, nice to have you back.
He was in the hospital. I actually went to visit him in the hospital. They said you can't do that. Then I scheduled a Zoom meeting with you, and they said, our bad, he got released. You can't Zoom with him. And now he's here. So I did speak to the lieutenant, Your Honor. And what I would like to do is adjourn today's date so I can talk to him about his matters. There's been an offer extended. But in addition, I'd like to address bond, Your Honor. My client is, I'm sorry, he has a lot of medical needs. He's been in and out of the hospital since he has been a part of the system. Your Honor, my client, we're asking that he be released. We want to put him on tether home confinement. We would be fine with that as long as he has the ability to go to all the medical appointments that he has. Yes, there you go. Sorry. Yeah.
The offense the defendant committed while he was on the bond or going to have the status of his other pending cases. Fully $101. Leave the bond on these matters is 1,010%. I think that's important.
And
Anything else?
so, Your Honor, that's my argument.
Motion for bond reduction is denied. Bond will continue.
Thank you. I did argue 3 times in jail.
Thank you. Court calls the case of the people versus Deja Banbury.
Jake Kennedy, for the people, Your Honor.
Stephanie Cannon on behalf of Miss Banbury, but not with, Your Honor. She was recently released from the mental health facility. When I spoke to her yesterday, she was going to come in, Your Honor. She is trying to get here. She doesn't have the vehicle, but she had recently been released from the mental health ward. So I'm just asking for an adjournment, Your Honor, or at least if we could push this to the side so I can call her and get her here.
Second, third, fourth failure to appear on this case, so I'm.
Your Honor.
Kennedy did.
He did, but Your Honor, all of these, for these processes, she has been involuntarily committed. So these are the reasons why she has not appeared. And we were able, I believe the reason we were able to get the report recalled is because of that. And we were able to show proof of that. So this is not a case where she's just not coming. This is just a simple or a matter of mental health needs. So if you would just set it aside, Your Honor, so I can give her a call and have her come in, make sure she's getting here. I am dying. I don't know.
No, don't say that.
Please.
Okay. Oh, I'm going to set it. I'll pass it briefly.
Thank
you. A little bit of time to get her here.
I will.
Thank you.
Yeah.
That's when you pass my case. I'm dying. Court does call the case. People versus Maisha Gaines.
I'm sorry.
This is
Ready again, Judge. Torres shall feast the Assistant Public Defender on behalf of Ms. Maisha Gaines, who will stand to my right at the podium. Please state your name for the record.
Maisha Gaines.
thank you.
Thank you, Judge. This is a similar case to the last one I had where we need to get our our police report in for no contest plea, and we're not able to get that done before the deadline. So we're asking for an adjournment to be able to get that in.
Probable cause conference will be adjourned to July 16th, 2026, 9 a.m. Bond continued.
Thank you very much, Judge. He adjourned it, plea enter, next court date based on all the information I had to send in to him.
Ma'am, I need certain paperwork. They're gonna get it to. And that's all, instead of 2 weeks, I've adjourned it out just 1 week.
Okay.
Okay?
All right. Thank you.
Thank
You're
you.
welcome. Court does call the case, People versus Malachi Beverly.
Your Honor. Your Honor, Amy Lucas, requesting permission to practice under Michigan Court Rules 8.120 under the supervision of Assistant Public Prosecutor Jay Bellinger.
Permission to practice is granted.
Could you please state your name?
Malachi Beverly.
You got him.
Your Honor, are looking to enter a no.
Hold on a second. You got him? Okay. Go ahead.
We're looking to enter a plea today.
I have before me a plea form that indicates that the defendant will be pleading no contest to 3 charges.
That's my understanding.
Count 2 is domestic violence, a 93-day offense. Count 3, assault and battery, also a 93-day offense. Count 4, malicious destruction of personal property, 200 to 1,000, the 1-year offense. Upon a successful plea to that charge, count 1 would be dismissed. Defendant is agreeing to complete a substance abuse assessment and follow all recommendations, including inpatient treatment or outpatient treatment. The prosecutor and defendant are agreeing to a sentence agreement of sentencing for count 2 under 7694A and for counts 3 and 4 under a prosecutor's deferred. That is the court's full understanding of the agreement.
That's correct, Your Honor. That's my understanding as well.
Sir, can you please raise your right hand? Do you solemnly swear or affirm testimony you're about to give will be the truth, whole truth, nothing but the truth, so help you God?
Yes, sir.
State your name.
Malachi Beverly.
Okay, you can put your hand down. Sir, it is this court's understanding you're going to plead no contest to 3 charges. First charge is the added count 2 of domestic violence, or actually stated count 2 of domestic violence. That's a misdemeanor punishable by up to 93 days in jail, a $500 fine plus court costs. Do you understand that, sir?
Yes.
Also, that you'll be pleading no contest to the charge count 3 of assault and battery. That's also a misdemeanor punishable by up to 93 days in jail, $500 fine plus court costs. Do you understand that?
Yes.
And also no contest to malicious destruction of personal property, 200 to 1,000. That is a misdemeanor punishable by up to 1 year incarceration, a $2,000 fine plus court costs. The fine could be increased to 3 times the value of the property taken if that's greater than 2,000 or destroyed. If that's greater than $2,000, that would become the maximum fine. You understand that, sir?
Yes.
Do you understand what a no contest plea is?
Yes.
2 things about it I have to make sure that you understand. The first thing is it means that you're not further desirous or wanting to contest these charges. You understand that?
Yes.
Second thing is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that?
Yes, Your Honor.
You understand that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Barr in the 1482 District Court.
Yes, Your Honor.
All right. Basis for the no contest plea?
Liability.
Sir, to the charge of domestic violence, how do you plead?
Guilty.
No contest.
No contest, I mean.
To the charge of assault and battery, how do you plead?
It's all no contest, right, John?
Yes, no contest.
Okay. So to that charge, you're pleading what, sir?
No contest.
Okay. To the charge of malicious destruction of property, how do you plead?
No contest.
Now, you understand that by pleading no contest, you will not have a trial of any kind.
Yes, Your Honor.
You signed or had cause to be signed on your behalf an advice of rights form. Is that correct?
I think I did.
Well, did you?
Yes.
To the court.
All right. Do you have any questions regarding any of those rights?
No, Your Honor.
You understand that you're waiving or giving up all of those rights, including the rights under paragraph 5, which are your trial rights.
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today to get you to plead?
No.
Anybody threaten you or coerce you in any way?
No.
You're doing this voluntarily and of your own free will?
Yes, Your Honor.
All right. Court has been provided and has reviewed Washington County Sheriff's Office report for their case number 2637598. Any objection to the court having reviewed that report?
No.
All right. Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of these offenses. Sir, I do have to advise you that if between the time I accept your pleas and the time of sentencing, if you commit misconduct as defined in the Michigan court rule, you would not be entitled to withdraw your plea, and the court would not be bound by any sentence evaluation or recommendation. You understand that, sir?
Yes, Your Honor.
All right. Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
And have I complied with the court rule?
Yes, Your Honor.
Court will accept the defendant's plea of no contest to counts 2, 3, and 4. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 1482 probation. Sentencing in this matter will be
July 30th at 9 a.m.
July 30th, 2026, 9 a.m. before Judge Barr.
Thank you, Your Honor.
Bond with its conditions will continue. Thank you. Court calls the case, People versus Dontrell Smith.
Morning, Honor. Raymond Cook to the people.
Good morning, Your Honor. Assistant Public Defender, Tanavi Carey, on behalf of Mr. Dontrell Smith.
Boy, I was waiting for you to show up.
Good morning, Judge.
Good morning. Mr. Smith?
Yeah,
Can you state your name for me?
Dontrell Smith.
Thank you. What are we doing?
So, Your Honor, I don't think we have much that we can do today. We're waiting for a competency report. I did receive the letter from the Forensic Center indicating they were needing about a month. They still had some documentation that they needed to get.
Today. All right. I'll adjourn the competency hearing then to August 3rd, 2026, 9 a.m. Bond will continue. Thank you, Mr. Smith. Court calls case People versus Robert Jameson II.
Brian Bowling on behalf of Mr. Jameson, Your Honor. Hey, morning. Can you state your name for the record, please?
Robert John Jameson II.
Your Honor, I'm asking for an adjournment of this matter. It's my understanding that Mr. Jameson was referred for screening for the Circuit Court Recovery Court in another matter. If you want, sorry.
It's screened already, or?
I do not believe so, no.
Have you been screened?
Told me they would be doing screening. I don't believe I have been yet.
He hasn't met with anybody yet, Your Honor.
I met with one person about.
If the next pretrial before Judge Slay is set for the 23rd in the afternoon, if that helps at all with the court.
Yeah, well, thanks, because I was looking at timing of it. You want? And that's the case that he's being screened for?
That's correct. That is correct.
I asked for the 30th this week.
Okay, I don't have the 30th, I have the 28th. That'll work. All right. Probable cause conference will be adjourned to July 28th, 2026, 9 a.m. Thank
Thank you, Judge.
you. Thank you.
Judge. Thanks, Judge.
Court does call the case. People versus Angelina Bonacera.
Asli Bashir on behalf of Angelina Bonacera, but not with, Your Honor. I was informed by Washtenaw County Jail staff that last evening Ms. Bonacera was transferred to Monroe County Jail. Are they on Zoom?
So she's been transferred?
Yeah, last evening, I think, ex-jail says around 4:30.
All right. Did they say is she coming back, or we don't know?
She's being held, actually, may I approach, Your Honor?
Yes.
Can a terrible childhood explain a terrible crime? Or does every adult have to face the consequences of their own choices? That emotional question took over the courtroom during one of the most powerful sentencing hearings you'll ever see. Before the judge announced the sentence, a forensic psychologist described the defendant's life growing up. He testified that Michael had witnessed years of domestic violence, drug abuse, and constant instability. According to the evaluation, both of his parents struggled with methamphetamine addiction. He moved from home to home, lived through neglect, and was never treated for serious mental health conditions, including PTSD and ADHD. The expert explained that years of trauma eventually led to heavy drug use and methamphetamine-induced psychosis. The defense argued that Michael wasn't born a violent criminal. They said he was a young man whose life had been shaped by abuse, addiction, and untreated mental illness. They asked the judge to consider treatment, rehabilitation, and a lower sentence, insisting that he had accepted responsibility for what he had done. But the prosecutor saw the case very differently. She acknowledged that his childhood had been difficult. However, she reminded the court that by the time he began using methamphetamine,